So my name is Greg Rinckey. I'm the managing partner of Tully Rinckey, and I'd like to welcome you all to our firm and our CLE tonight on Userra and the Service Member Civil Relief Act. A little bit about myself. I was a former Army JAG officer for 6 years, and that's where I got my first taste of dealing with Userra and with the Service Member Civil Relief Act. Tonight we're going to give you a broad overview. I gave you a lot of stuff in your handouts that you can take home with you to digest. The Service Member Civil Relief Act has changed a lot over the past couple of years, and there's a lot in Userra that we're just going to touch on. But you have the handouts which will go into more depth. What we're going to talk about tonight is basically Userra, the statute, what it protects against, basically discrimination and reprisal on military service. It basically protects against the denial of a benefit of employment. Also protects against the right to reemployment, and we're going to talk about entitlements during service. And then we're going to end tonight on the Service Member Civil Relief Act. This is an area of law that we're seeing more and more complaints being filed on, especially with the global war on terror. We're seeing a lot of reserve units and guard units being called up, and then we're seeing them be recalled up a few years later. And a lot of employers, they feel that, the first time, okay, I'm doing my civic duty, but then by the second and third and fourth time, all of a sudden now it's becoming a burden on my organization. So we're seeing a lot more complaints coming in. A lot of times we're seeing complaints come in with employers that just don't know the law and just think that they can basically not hire someone because of their military service or just ignorant of the law. Uniform Services Employment and Reemployment Rights Act of 1994 was basically the last adjustment to the law, and it protects against unlawful discrimination against military service members, including members of the Guard Reserve, due to their military performance or obligations. And it's important to remember that it doesn't just apply to members who are actually in the Guard and Reserve. It actually applies to people even before they join the Guard and Reserve. If you have someone that comes into your organization, you hire them as an employee, and they say, hey, I need to take off on Monday to go to the MEP station to take my military entrance processing exam. You say to them, you can't do that, I got something else scheduled. You can be held in violation of Userra before they're even in the armed forces. So there's a lot of nuances with Userra of what it protects for. It also protects against discrimination after people get out of the military if you discriminate against them based on their military service, if they have a disability. And we're seeing a lot more of that with guys that are coming back from Iraq and Afghanistan that have disabilities related to their service. It requires employers to reemploy service members following a period of service of less than 5 years. And that 5 years is very deceptive because that 5 years has a lot of exceptions to it. And basically the whole global war on terror and Iraqi freedom is an exception to that 5 years. So it won't count towards that 5-year period of service. So you really have to look at the service member's orders to determine whether or not it's exempt from that 5 years. And what this really does is it really protects against someone becoming what we call having two careers. And we see some soldiers that actually play the system and they can have two careers. They can have a Guard and Reserve career and actually get almost an active duty retirement off of that. And they can also have a second career with a civil organization or with a private organization. And what some of them do is they play the system, and what happens is they're on active duty for a year, then they come back and they say, oh, I'm going to extend, and they keep extending it to the point where it's now year 6 or 7, and they come back and they say, I want my job back. Well, this provision says that you don't have to hire them back if it's been more than 5 years of cumulative service. However, there's many exceptions to that. There's exceptions for certain types of training, the global war on terror, and parts of Iraqi freedom are exempt from that. So you really need to look at that 5-year exemption. Covers all employers, no matter the size. Doesn't matter if you have 100 employees or you have 3 employees. And it includes a denial of any benefit of employment, not just employment itself. So we have cases where guys come back and they say, I'm being denied, vacation time, I'm being denied promotion, I'm being denied all sorts of benefits of employment. So it doesn't just deal with employment itself. It's important to remember, though, that Userra is an escalator, is the way we like to phrase it, which means it can go up and it can also go down. And what do I mean by that is Private Snuffy comes into your organization, gives you notice and says, I am deploying tomorrow. Well, you have to let him go. He comes back 3 years later and says, I want my job back. Well, in those 3 years, let's say your organization hit the recession and you laid off maybe 20 people. And Private Snuffy's job would have been one of those that were laid off. Do you have to hire him back? You have a defense there where you could say that if you had been here, you would have been laid off. Now, where does it look suspicious? Private Snuffy comes back and says, I want my job back. And you say, oh, sorry, your position was eliminated. Well, how many other positions were eliminated? Just yours was eliminated. So that's where it looks a little suspicious. So Userra works as an escalator where it can go up and go down. Private Snuffy comes back and he says, I've been gone for 4 years. I want my job back. You not only have to give him his job back of where he left, but you actually have to bring him to where he would be. So that's why we say it's an escalator. So if he would have had a promotion, he would have had a pay raise, it's an escalator. So you have to bring him to where he would have been. We're going to talk about leaving civilian job for voluntary and involuntary service in the military. What that basically means, and I get a lot of employers that come in here and say, well, I don't have to hire him back or I don't have to let him go because he volunteered to go. Doesn't matter. If you have an employee who's in the Guard or Reserve and comes in and says, I volunteered to go to Afghanistan, it's just the same as if he was ordered to because he's going to come down on orders. Now, do you have to, does it apply to spouses or family members? It doesn't. Userra only applies to the actual service member. Can you require them to show you orders? No, you can't require them to show you orders because sometimes, like after 9/11, Guard units were getting phone calls saying, hey, you're activated. And a lot of these guys were able to just go into their jobs and say, I've been activated, I got to go. So there's no requirement to actually show the orders. Now, what do I advise service members to do is to always, when you give notice and give a copy of the orders. But it's not required under the statute. There has to be an employer-employee relationship. This is very heavily litigated, as you can imagine, and I think we have some of the material in the cases in the material that we gave you. This is one of the biggest defenses that employers sometimes say is, hey, he was a contract employee. There's no employee-employer relationship, and the courts have interpreted that different ways. So that's something that you really need to look at. Types of employers. There are some exemptions under Userra, and it includes religious institutions. And where we see that, we actually had a case with a Catholic university where we had someone who was a chaplain, got activated, came back, and they basically said, we don't need your services anymore. And they put forth a defense that, hey, we're a religious organization, and the court upheld that. So it's something that you need to look at because there are some minor exceptions to and exemptions to Userra. Native American tribes, foreign institutions, and international organizations are exempt from Userra. You're not going to run into them too many times. The size of the employer and the number of employees is not relevant for Userra, once again. And discrimination and reprisal. So it's unlawful to deny under Section 4311 of Userra. It's unlawful to deny an individual initial employment, retention in employment, promotion, or any benefit of employment because of individual service. And where we see this happening a lot is you have a lieutenant who's in the Guard or Reserve, he's applying for a job, and on his resume, what does it say? It says First Lieutenant, Second Lieutenant, United States Army Reserve, and the employer says, whoa, do I really want to hire this guy or gal because, they're probably going to get deployed. So we're seeing that a lot to the point where a lot of military people now won't even put it on their resume. And what we see sometimes is that lieutenant will come in and say, hey, they loved me, they offered me the job until they found out that I was a lieutenant in the Guard or Reserve, and then all of a sudden the offer was pulled from me. So that's what it says, that's what it means by when it says unlawful to deny an individual initial employment. Retention in employment, we have this all the time where somebody comes back from an activation or a deployment and the employer says, you know, Johnny, I really need you to make a choice here. Either you're a team player on our team, or you're going to play, you know, weekend soldier every other weekend, or, you know, you're going to deploy. We see that happen a lot, where employers are actually telling, you know, service members that they need to make a choice. Obviously, that is unlawful under Userra. Promotion, this is where it gets sticky, because a lot of times you have service members that deploy, they come back, and under the escalator principle, they should be promoted with their peers. If their peers are being promoted, they should be promoted just as fast. A lot of times you have employers say, well, wait a minute, that's not fair. He hasn't been on the job as much time as, you know, employee A. Well, it doesn't matter. Under Userra, it's an escalator. So under Userra, it's counted as if they had still been employed with the firm or with the organization. Benefits of employment, we talked a little bit about. Benefits of employment deal with vacation accrual, bonuses. Where some of these cases get sticky is you have someone who is working as a stockbroker. He deploys. What do they do with all of his clients? They redistribute them to someone else. He comes back and he says, hey, I'm back. I want all of my contacts back. Well, a lot of times employers aren't so comfortable with taking contacts back and giving them back to the initial person. So we sometimes see litigation in regard to stockbrokers and other people that have client interaction. And it's interesting to see how the courts have come down on that. And a lot of times the court splits the baby in whether or not you have to give them back their contacts. Standard of proving a violation, you must prove that the plaintiff's service was a motivating factor for the employer's decision. It's basically once you make that initial, once you prove that initial burden, the burden then shifts to the employer to disprove it. And the employer basically has to come up with another reason as to why they would have made the decision but for his military service. Right to employment, eligibility criteria. It's very important to provide the employer advance written or verbal notice of the orders. So it can be a phone call of I've been activated. It can be written notice. Once again, there's no requirement that they have to show you orders. A lot of employers come back to me and say, well, I think Private Snuffy or Sergeant Jones is pulling a fast one on me. He's always got guard duty or reserve duty. Well, there's ways around that where you can call the employer in, and at that point you can then ask for proof that they are in fact drilling. You have to be careful, though, that you're not calling their commanding officer and trying to find out if they are in fact drilling, because you could then be in violation of Userra. Do not exceed the cumulative 5-year service limit. Now that is not just 5 years all at once. It can be 1 year here, 3 years here, 2 years there. Where you see this happening a lot is there's a lot of guys that are in the Guard and Reserve, and I don't know if many of you know this, but 20 years of service is a retirement. So what a lot of guys try and do is they try and get in that 20 years of service so they can get a military retirement. If they work for the government, they can also then get a state retirement, so they can sometimes double dip. Military members, and I don't know if is anyone here a state employee? Does the state pay if they go to do drill? Do you know if they double dip?
Not sure.
Okay, because in the federal government they do. The federal government gives you 15 days a year where you can double dip. So the Guard and Reserve, they get paid their military pay and they get paid their federal pay. So a lot of them, what they try and do is they try and play the system so they can get a federal retirement and they can also get a state or a military retirement. So what happens with a lot of them is what they'll try and do is they'll try and squeeze in a military career while at the same time either having a state career or a private career. And Userra is really not designed to protect the professional soldier. It's designed to protect the soldier who is the Guard, the Reserve soldier. It's not there to protect someone who's going to become a full-time active duty soldier. It's there to protect someone from being called up to active duty, and then when they come back, their job isn't there. We see it happening with a lot of smaller firms, organizations, because they just don't know the law. Unfortunately, though, some of you may have seen this in 60 Minutes. The VA actually discriminated against a nurse that had deployed for 2 years, and she came back, and it was in writing from her supervisor saying, sorry, your job isn't here anymore. And on 60 Minutes, the head of the VA had to do some explaining, which he actually gave his home phone number out during. It was pretty interesting. So the 5-year service limit is something that you really need to look at, but like I said before, there's a lot of exceptions to that 5-year service limit. Contingency operations don't count, certain training doesn't count, global war and terror doesn't count, Iraqi freedom doesn't count. So really when you look at it, sometimes the exceptions swallow the whole rule. So it's something to just be aware of. You have to return to work or apply for reemployment in a timely manner after deployment service ends. And the time period to request reemployment is determined by the length of your active duty. So what does this mean? This means that you can't come back from active duty and then sit at home for a year and then go back to your employer and say, I want my job back. You have to timely apply. It's either 90 days or 180 days. And usually what we tell service members to do is when they come back, they need to do this usually in writing or send it certified or in fax so that there is a proof that you have requested your job back. There's also another requirement, which I don't know if we put in here, served honorably. And what does that mean is they have to have an honorable discharge from active duty. And usually what you'll request as an employer is a DD-214, which down the bottom will have the type of discharge that they received. So if they come back and they got a general discharge or an other than honorable discharge, USERRA does not apply to them. Right to reemployment, the affirmative defenses.
What does that mean, Iraqi freedom doesn't count?
They've determined that these are contingency operations, and I guess based on the reliance and the need for the Guard and Reserve, they've been exempted from USERRA. So it's it's strange to me too. I don't know, Mike is our expert on that. Do you know why they did that?
I haven't seen why they exempted it, but they've chosen certain wars, certain encounters, and it actually goes further back. If you look back, certain service called upon by the president can be exempted as well. And sometimes they'll exempt service even after they've served. So they'll go back and be gone, and then all of a sudden the law, the rule changes, and it goes back. It gets really interesting at that point as to what qualifies or not.
Yeah, we've done a lot of litigation with this 5-year rule because a lot of times that's the first thing that the employer will say is, oh, you're over your 5 years. And we say, well, wait a minute, maybe not. And we look at it, and a lot of times there's a lot of exemptions, and you can actually go through their orders and find out that maybe 6 weeks might have been for training or something and get them under that 5 years. So there's a lot of loopholes to it. Right to reemployment, the affirmative defenses, the individual's pre-service employment was brief or non-recurrent. You know, that's basically the temp worker, you know, who's maybe a temporary security guard or, you know, someone that's seasonal or something, and they come up and they say, hey, I got orders to deploy. They come back 4 years later, and now they say, oh, I want my landscaping job back. Well, if it was really a temporary, brief, or non-reoccurrent job, they're not going to be protected under USERRA. Circumstances for the employer have changed. We've seen a lot of this with the recession after 2008. A lot of guys that deployed, they came back and they're saying, hey, my employers are saying, you know, when I came back, that my job isn't here anymore. You know, that they had layoffs or that, you know, they outsourced. Well, what we have to look at is we have to look at and see, was the Guard and Reserve soldiers that came back, were they the only ones that were affected, or did this affect a whole unit? Did it affect everyone in your year class? Because if it did, like I said, it's an escalator, and I explained to them the escalator can go up and down. It's basically as if you had never left. So if you had been here and you would have been laid off, USERRA is not going to protect you. USERRA is basically to put you back where you would be if you hadn't got off the escalator. It's a heavy burden of proof for both. So like I said, a lot of times employers will make that argument where they'll say that your job has been eliminated, and usually when we dig down and through discovery we find out usually Private Snuffy's job is the one that's been eliminated. USERRA entitlements during service. Furlough or leave of absence clause, basically it's as if they haven't left, so you treat them pretty much the same. Continuation of civilian health insurance coverage. It's not automatic, but they can elect to take it. You don't have to pay the premiums if you're the employer. You can charge the employee 102% of the premium if the period is over 30 days of service. So they're entitled to keep their insurance, but you don't have to pay the premiums. You don't have to cover that. Other issues, recent decisions. This is a pretty important decision that's very recent from Userra. It's Staub v. Proctor Hospital, and this deals what we call the cat paws theory. In this case, the supervisor was the one that was basically doing the anti-military bias, and it caused an adverse employment action, and it was the proximate cause, basically, of the employment action. The employer was liable. Basically, what the employer tried to say is well, we're not, we didn't discriminate under Userra. A low-level supervisor did, so you can't hold the employer liable for that. Well, the court came back and said, supervisor can be, their acts can be attributed to the employer. So that's a pretty landmark decision that came down very recently.
Greg,
Yeah.
just to go back for a second,
Yep.
to the fringe benefits?
Yeah.
Are there any other fringe benefits other than the one you mentioned, health insurance? I was thinking of two things in particular, where length of service is an indicator for, say, vacation credits. Are they entitled to those accrued vacation credits as if they were on the job?
That's an interesting point.
The other one that I thought of is some employers have life insurance. Is the employer allowed to cancel the life insurance while the person is...
Okay, life insurance is in the New York State military law. In New York State military law, it says you can't cancel it, but you can charge the premium to the soldier, and they have a year from the time they come back to make up the premiums. The other issue in regard to vacation accrual, that's a gray area, and right now we're actually litigating a case on that very issue that you raised as to, we have a police officer his vacation is based on the year before's service, and he came back, and basically his employer is now saying, well, you weren't here last year, so you get zero vacation. Well, that's not my reading of the law, and I think he's entitled to it. It's as if he had been there, so he should be entitled to vacation accrual. Now, what happens is you don't accrue vacation while you're on military. So what you can't do is you can't come back and say, I was gone for 4 years, I want my vacation days while I was gone. That is clear. You don't get those. But what I think is unclear is when you come back, if the next year's vacation is based on the previous year, I think then for purposes of setting your next year's vacation accruals, it should be as if you hadn't left, is my argument. But Mike is actually handling that case too. So I think I summarized that pretty well, right?
I think the breakdown comes to, and it can be interesting, we don't have a clear answer yet, but whether it's an entitlement or an accrual. If it says you've been here 20 years, you get 3 weeks vacation, that's an entitlement. If it's every 2 weeks you get 0.3 hours of vacation, that's an accrual. And I tend to agree with Greg, but I think the entitlement argument is that you do get that. The accrual, it's a little less clear.
But it's pretty clear cut that you don't get your vacation days while you're on active duty, unless you work for the federal government. If you work for the federal government, you do, because you get 30 military days per year. It's 30, right? Right, Mike? Is it 30? 15, but then I gave you 15 additional now for contingency operations.
There's all kinds of exceptions to that too, but they can sometimes increase it.
Yeah.
And you do see that a lot. Sometimes they give you additional protection than what Userra has.
So they can come back and cash out those days. Did that answer your question?
Yes, thank you.
Yeah.
What if you're a police officer and you need a year in grade to advance? Purely hypothetically speaking, you're gone. You miss it by 2 months.
You miss it by 2 months because you're...
But we're called to active duty.
My argument would be is if you hadn't left. You know, you're entitled to the... We litigate those issues all the time. We have that with firemen, EMTs, police, where they say, oh, the requirement is you be on the job for a year. My partner actually litigated a case like that when he worked for the Bureau of Prison, and he won his case, basically. He was gone for... He basically came on the job, he was there for like 2 or 3 days, got activated, came back 3 years later, and they said, oh, you're going to be sweeping the floors. And he's like, I've been here for 3 years, and litigated that case. So A lot of times, though, municipalities, they don't understand the law, and they'll say, sorry. Another thing that happens, too, is a lot of times promotions occur while they're deployed. And you have an obligation to either give them notice, and a lot of them say, well, he's in Iraq, how am I going to give him notice? Well, then when he comes back, or she comes back, you're supposed to then have a special promotion board. That's the way to remedy it.
So if you promote, let's say promote a sergeant to a lieutenant,
Mhm.
right? The person's in Iraq who should have got that promotion.
Mhm.
They now return.
Mhm.
They prevailed. They were number one slot on the list.
Mhm.
What do you do? Undo the promotion?
Well, no. I mean, at that point, if you knew that he was number one on the list before they went, I would say you should promote that person.
Okay.
I mean, if they weren't, a lot of times what happens is the promotion occurs and they weren't given notice, they don't know about it, or you didn't tell them about it, and you don't know where they fall on the list. And then the argument is, okay, well, there should either be a special promotion when they come back, or if not, when they come back, they need to be given preference on the next promotion list. Yeah, it gets messy, especially with small police forces and fire departments, because that's the argument that the municipality is going to say is we had to promote somebody.
Yep.
You know, what are we going to do? Undo the promotion? You know, so a lot of them handle it in a fair way, and when they come back, they say we're going to give you we're going to hold a special promotion board, and then they can promote them at that time. Or what they can do is the next time there is a promotion board, if they do the smart thing and they talk to their lawyer might say, well, you know, under Userra, you probably should promote this guy if he would have been number one on the other list, because we have a case like that where this guy kept getting passed over. And now, you know, it's not just the first promotion, but now we're saying, hey, if you had promoted him then, he'd be a captain by now. So it can get messy as it goes on.
Well, it's an issue now because a lot of these promotions, not a lot, but a fair amount of these promotions are funded by grant funding, which for the first time in the state's history is going in a negative direction.
Yeah.
So
Yeah.
the guy comes back, now you have no money, what do you do?
Yeah, I mean, that's settled the case probably. That's what we see a lot. Let's see, we talked about Staub. Erickson v. United States Postal Service. This is our case, just for disclosure. The Federal Circuit came back in February 28, 2011, and said because the 5-year period provides a distinct termination point for Userra's reemployment rights, the enactment of that statutory period makes it reasonable to assume that absent clear evidence to the contrary, an employee who have not exceeded that period do not intend to abandon their civilian position. In this case, basically the post office, their argument was when Sergeant Major Erickson tried to get his job back, they said, well, you told everyone that you wanted to go back into the military, you know, and you basically had abandoned your postal career, even though he hadn't been over the 5-year limit. Well, the Federal Circuit came back, and the Federal Circuit said, no, absent any other, there has to be basically explicit and clear evidence to the contrary. He did not abandon his postal position. So this was remanded back. So stay tuned for that one. But that's a lot of times a defense that an employer will use, is that they abandoned their job. And sometimes what happens is you have someone that, you know, they get called up, you don't hear anything from them for 4 years, they come back, and all of a sudden now they want their job back. And, you know, a lot of times someone in human resources might not even remember who you are. So that's usually the defense that they'll throw out, is that you abandoned the job. Service Members Civil Relief Act, this has changed quite a bit. It used to be called the Soldiers and Sailors Civil Relief Act. This now gives a lot more protection than under the Soldiers and Sailors Civil Relief Act. Userra does not fall under the Service Members Civil Relief Act. Section 502, temporary suspension of judicial and administrative proceedings and transactions that may adversely affect the civil rights of service members during their military service. I mean, it's kind of common sense that if someone is deployed to Iraq or to Afghanistan, they're not going to be able to come back to defend an action, so there should be a stay. We actually have a case in Virginia where, unbelievably, the judge held a service member in contempt for not coming to court, and she's over in Korea, and she actually had invoked the provisions of the law. So sometimes I guess you get judges that might not understand it, or I don't think they're above the law. So you sometimes see judges that will come across it and not understand what the provisions apply for. They don't apply to criminal proceedings, obviously. Section 512, jurisdiction of the Act is United States, all territory within the United States. notification of benefits under Section 515. Basically, service members are provided the Service Member Civil Relief Act during initiation, when they mobilize, when they enlist, and when they're called to active duty for a period of more than 1 year. So a lot of them know their rights. Some of them know their rights better than I do. General relief under Section 521 is a protection of service members against default judgments. And a lot of times you'll see this in the court papers where it'll actually say service member is or defendant is not in the active military service, and sometimes you actually have to affirm that. Applies to any civil proceeding in which a defendant does not make an appearance. So they give great protection so that you can't enter into a default judgment against them. Section 522 is a stay of proceedings. When service member has notice, it applies to any civil action or proceeding in which defendant, at the time of filing an application under this section, is in the military service or is within 90 days after termination or release from military service. So it protects you not only when you're actually on active duty, but it protects you even 90 days after you're off active duty and has received some notice of an action or proceeding. General relief, fines and penalties under contracts, prohibition of penalties, provides for some reduction of waiver of fines and or penalties. Let's get to the good stuff here. Section 524, stay or vacation of execution of judgments, attachments, and garnishments. Applies to any action or proceeding commenced in a court against service member before or during the period of service member's military service or within 90 days after such service terminates. It's important to realize here that military service has to adversely impact your ability to defend. And this is sometimes the case where you'll get someone who gets served with papers in family court or something, and then they'll tell you, well, I happen to be going on leave to Virginia. Well, if your court action is pending in Virginia and you're invoking this, you're going to have a problem if you're going to be in the state of Virginia, because then you probably have an affirmative duty to let the judge know that I'm going to be in Virginia, because it's not going to adversely impact their ability to defend. Just by the fact that they're on active duty also doesn't adversely impact their ability to defend, because they also have to, I mean, you know, if you are stationed in Fort Belvoir, Virginia, and you get notice of a court action, well, your commanding officer might let you go to the court action. So sometimes you need to have a commanding officer who will say that they're not reasonably available because of the fact of military service. Same thing with Korea. Sometimes we see that in Korea where they could fly back, but a lot of times the commanding officer will say that they're not reasonably available due to their military service. Obviously, if they're in Iraq or Afghanistan, you know, basically orders are going to be enough. Rent, installment contracts, mortgages, liens, assignments, and leases. This is where the law has really changed. The law in the past under the Soldiers and Sailors Civil Relief Act was very weak in being able to break contracts, installment contracts, cell phone contracts, and leases. But this now actually provides great protection. Section 531 is evictions and distress. This is the important point here, is where it says except by court order. Doesn't mean that you can't evict a service member. You can do it if you have a court order. And I actually did a consult with someone last week where they had a service member who was residing in their apartment, and the guy was destroying the apartment. He was making holes in the walls, wasn't paying rent, and every time you try and talk to the guy'd say, well, you know, I'm in the military, you can't evict me. Well, that's not what this says. This says that except by court order, a landlord or another person may not evict a service member or dependent of the service member during a period of military service that are occupied or intended to be occupied as a primary residence, and for which the monthly rent does not exceed $2,400, which actually has now gone up to $2,465, subject such premises to distress during the period of military service. So it doesn't mean you can't evict someone. You have to have a court order. So, I mean, obviously, if they're in breach of the terms of the agreement, they're destroying the premises, they're creating a nuisance, or they're not paying rent, you need to go into court, and you need to get a judge's order, court order, and you can still evict them. What this is really meant to protect against, this is, you know, Sergeant Jones, who is renting an apartment off post. He gets deployed to Iraq. He leaves his family behind, and now maybe they run into some money problems or something. You can't evict them during the period of that service member's service. That's really the primary reason that this was enacted. Mortgages and trusts, an obligation of real personal property owned by a service member that originated before the period of the service member's military service and for which a service member is still obligated and secured by a mortgage, trust deed, or other security in the nature of the mortgage. Well, we see a lot of times what people try and do is you can reduce the amount of your interest to 6%. There's a statutory cap. Now with interest rates, it's not as great as it used to be, but if someone gets called up to active duty, what they can do is they can come back in and they can apply to have their interest rate reduced to 6%. However, there's a few things. It had to have originated before military service, not during military service, and then their military service has to adversely impact their ability to pay. And that's not always the case, because sometimes when they get called to active duty, if they're a pizza delivery guy on the civilian side, they get called to active duty and they're a second lieutenant, well, guess what? Now they're making more money, so they're not adversely impacted. What this is really meant to do is this is, the attorney who potentially is, in a large law firm, has a mortgage, his interest rate is 8%, gets called to active duty, and let's say his salary in the civilian side is $150,000, gets called to active duty, and he's a captain in the JAG Corps. Maybe he's making $80,000. Well, now his ability to pay has been adversely impacted. So you could then petition to reduce it to below 6%. And we see a lot of banks, unfortunately, denying these, and this has been in the news quite a bit. Any questions on that? Okay. Termination of residential and motor vehicle leases. This is where the Soldiers and Sailors Civil Relief Act fell short back before the initiation of the Service Members Civil Relief Act. Is now you can terminate residential and motor vehicle leases. And basically what that comes down to is it can be terminated when they enter military service, and basically it can also be terminated or terminated when there is a permanent change of station for more than 180 days or deployment. And this applies to leases of premises, motor vehicles, and also, we didn't put everything on here, but basically applies to almost any type of contract, which would be a cell phone. And it has to be more than 180 days. The way it works with a lease is if you're going to break your lease, you have to give notice. If it's a month-to-month and you pay, let's say in the first of the month, you pay if your rent is due on the first of every month. Let's say Sergeant Snuffy gives notice to his landlord on let's say May 15th, it would not take effect until 30 days after the next rent would be due, which would be July 1st, would be the quickest that they could break the lease. And you can't charge any type of fee. So if you have a lease on a nice car and you say, hey, I just got orders, I'm going to be moving to wherever you're moving to, or you just got orders to go to deploy, Toyota cannot say, well, you're breaking your lease early, I want to charge you a fee for that. They can't do that. That's prohibited under the Act. Taxes in public lands. This really doesn't come up that much, but Section 561, taxes respecting personal property, money, credits, and real property. This applies in any case in which a tax or assessment, whether general or special, other than income tax, falls due and remains unpaid before or during a period of military service. So basically, it's almost a stay is really what happens in that regard. Rights aren't forfeited, and temporary suspension of permits or licenses. Same thing in New York, like your driver's license. If you're on active duty, you don't have to renew your driver's license. You can basically, if you're in military service, you can let it almost expire. You're supposed to give notice to the Department of Motor Vehicles, and then when you come back, it gets reinstated, and there's no fee for that. That's usually where most lawyers see this, is service members come back and say, my driver's license is expired. It's not a big deal if they were on active duty. Further relief, Service member may, during military service or within 180 days of termination or release from military service, apply to a court for relief from any obligation or liability incurred by the service member before the service member's military service, or from a tax or assessment falling due before or during the service member's military service. This is really where the guy comes back and comes in, sees you and says, hey, I got a tax bill unpaid. You can basically go back to a court and apply for relief from that. I know we went through this pretty quick. It's almost actually 7 o'clock. Question?
What if you're a lawyer? You're deployed for 3 years,
Mhm.
take no CLE courses, and you lose your license.
In New York, you're exempt. In New York, you're exempt from CLE. Now, in some states, you're not. And I have a bone of contention. Do you have an issue with that? Or?
No.
Oh, okay. Well, I could tell you my personal story. I was called to active duty. I was licensed in New York and New Jersey. New York said, okay, you don't have to pay bar dues. New Jersey said the same thing. You don't have to pay bar dues. New York, exempt from CLE. New Jersey said you're exempt from CLE when you're in the active service. But when I got off of active duty, New York said, fine, no problems. New Jersey said, well, we have this kind of baby CLE thing that you need to take, which is like, I don't know, 6 weeks of going to New Jersey. Now, this is 6 years after I had been a practicing attorney. And to this day, I still can't practice in New Jersey because they want me to take this class. Now, is that a violation of Userra? I don't know. But New York, you're exempt. You're exempt from bar dues. You're exempt from CLE. And most states are the same. However, it becomes a question of, hey, if they have this policy that you needed to take this initial course of CLE, and some states do require that, New Jersey says you're not exempt. And I guess no one's challenged them on it yet. So, yeah, that's an interesting question. We're seeing more and more of these cases, especially with Userra, especially as you're having more people deploy and now they're on their 3rd deployments. And it's really, I could see both sides of the coin here. I mean, I could see how it could hurt a small business. If you're a small business and you're relying on, your employees, and you never know when they're going to come in and say, I'm being deployed, I could see their point as well. And a lot of small businesses are trying to petition for a tax credit for employing reservists and National Guardsmen. We're seeing some movement at the SBA for that. Other things that happen a lot of times is retaliation. Someone brings up a Userra action and then there's retaliation. That's protected under Userra as well. Sometimes it can be a very weak Userra case and we actually win on the retaliation. So that's a lot of times what we see as well. Any other questions?
Your driver's license is expired.
Mm-hmm.
You were in, how many days do you have when you come back in New York State to re-up it, reinstate it?
I'm not sure if it's 6 months or they give you quite a while.
Because I got in the back of my head, there was somebody got a ticket for an expired license.
I'm not sure. We can look that up and get that back to you. But yeah, if they were on active duty. But I think there's a requirement that you're supposed to notify the Commissioner of Motor Vehicles when you're on active. I kind of remember having to fill something out. But you might have an argument where they might just dismiss it in the interest of justice.
You ever see a situation in which an employer is forced to take somebody back under Userra, and then within a month or whatever, attempts to fire them for cause?
Yes, and there's a prohibition against that. Basically, it's a presumption. Mike, is it 6 months?
I think if your service was less than 180 days,
Yeah.
if your service was less than a year, they have to keep your position for 6 months, and if your service was more than a year, and that number might not be exact, they have to keep you for 1 year. So there's like a grace period where they can't terminate you for.
Yeah, it's almost a
unless
presumption that
there's
your
some sort of
military
gross
service.
exemption there, exception.
I mean, obviously, if the guy comes back and is completely screwing things up, and then you could terminate him. But a lot of times, what we see is exactly what you said. We'll take you back, you're fired. We see that, and that's usually a pretty easy case for us to make. And I'm pretty sure there's a presumption that the military service was a motivating factor for that. You'd be surprised at what people put in reviews. I mean, we have cases where they say, you're a great employee, but for your military service. But for your absences due to military. So you'd be surprised what people put in there. and it makes our life a lot easier. So I know you're all eager to get your CLE certificates and get out, especially in this rainy weather. So if anyone has any questions, or if you ever have a case, or feel free to give me a call and see what we can do to help you.
You get lawyer's fees on this?
Yes.
Yeah, equal justice, equal access to justice?
No. The way it's worded right now is the judge in their discretion may award attorney fees. We've tried to get that changed to must or shall. Usually we're pretty successful in getting attorney fees on these cases. But yeah, that's always been the bone of contention, is it says may and doesn't say shall. Like under EEO case law, yeah, it's shall or must. And we'd like to see that under Userra. All right, well, have a good night, and I'll stick around if anyone has any specific questions.
Right.